Okay. Well, thank you for coming to this breakout session. I'm Jared Tingy. I'm the legal director for the Utah League of Cities and Towns. And it's great to have Dr. Nilsson here with us. He is a professor from the University of Arizona. And he is quite an expert in the topic of impact fees today. He is Professor Emeritus of Planning and Real Estate Development at the University of Arizona, and is also the Presidential Professor Emeritus at the University of Utah, where he founded the Master of Real Estate Development program, the doctoral program in Metropolitan Planning, Policy, and Design. And he's also known for pioneering work in the implications of demographic change on land use planning and development, public facility finance, and metropolitan development patterns, among many other fields. He's written nearly 30 books. That is a lot of books. And more than 400 other published articles and works. So we're grateful to have you here with us, and we're going to introduce these other folks that we have here as well. Ross Ford, he said that any hard questions he'll take. So it's good to have him here. He is the Executive Vice President of the Utah Home Builders Association and has been a builder for 34 years. He's a part-time professor at the Utah Valley University as well, and studies upcoming technology and meaningful changes to the law to improve homes, and grateful he's here with us as well. And then Nicole Cottle, grateful that you're here with us. I remember the first time meeting her, and she knew her stuff. It was about, 6 or 7 years ago, where I met with her in West Valley City and getting advice from her. So she is a licensed attorney, and after retiring from a 25-year career in municipal government, she now is with Utopia Fiber, the Director of Government Relations and General Counsel, and now provides public-private partnership facilitation services on behalf of the state of Utah over the last 4 years, and has helped many projects connect to financing, building partners, and other necessary players to bring successful partnerships to fruition. So we're thankful to have them here with us, and I'm going to turn the time over to Dr. Nilsson for a presentation, and then after that, the panelists are open for questions. So we'll go to that.
Great, thank you very much. I'll have a presentation. When I was teaching at the University of Utah and Arizona, for some reason the dean would always schedule me for 3-hour sessions. So I'm used to 3-hour lectures. So brace yourself. I will go through the presentation. I'm going to frame the issues around impact fees, exactions, focusing on the recent Supreme Court case, Sheets versus El Dorado County, California. And then I'll end with a series of questions to the panel, to the audience, and that will tee us off. So it's wonderful to have a moderator who knows what he's doing.
Be careful.
Be careful. So when I first read the case that came out earlier this year, Sheets versus El Dorado County, it's an impact fee case with a lot of implications for local government. I thought the sky is falling. I still think the sky is falling, but we can talk about that with the panelists a little later on. So what is an impact fee? It is a one-time charge on new development to generate revenue the local government needs to build roads, water, sewer, fire, police, and other things. But impact fees are calculations. You have to show that there's a reasonable relationship between the impact of development on facilities and that the fees that you're charging are related to that cost. And impact fees cannot exceed the cost of development on facilities. Moreover, the impact fees themselves have to be used in ways that benefit the development paying the fees. In a sense, impact fees are a form of gap financing. So if we do our planning, our facility planning, we have a 20-year plan and we know where the money is going to come from, the state and some taxes, everything else, and we fall short. So impact fees will make up the difference. At least that's how I approach impact fees. Why do we have them? Well, government is broke. Citizens don't want to pay for anything. But citizens don't want to have their facilities become degraded because of new development. Legislatures always come up with new unfunded mandates. So local governments are getting broker and broker as legislatures add more and more things without paying for those things. But there's also an efficiency argument for things like impact fees. Impact fees are a relationship to development patterns. If your development pattern is low density, that means your cost per residential unit for infrastructure will be high. But if you increase density, that could mean that your impact fees would be on the lower side per unit. Or you can have something that's perverse. You can have an impact fee that is the same across all across all residential land uses, single-family detached mansions or the studio apartment. I've seen this around the country. If an impact fee is the same for those types of units, then you get fewer smaller units because they can't afford the impact fee. But then you get more larger units because you're undercharging them. And then you have a perverse fiscal outcome where you're building more larger homes that are being undercharged, and then suddenly your infrastructure bills also increase. There's some confusion about the difference between an exaction and mitigation. We use the term exaction all the time, or even extortion sometimes. An exaction commonly is where we have the developer, as a condition of approval, put something up, land for parks, land for schools, or whatever it is. Impact fees are a mitigation device, not an exaction, although the two terms are interchangeable. But impact fees mitigate the impact of development on facilities. And mitigation carries with it a more precise meaning in planning, my practice, or in the law, where mitigation is tailored to offset the maybe not quite precise, but close relationship between the impact and the mitigation that's sought. Where exaction can be much more wide open. So the Dolan cases came out of Dolan was California a few decades ago. Dolan was Oregon. In both those cases, they were exaction cases where in Nolan, the California Coastal Commission wanted Mr. Nolan to give up a lateral easement across their yard so that people could walk from one side of their yard to the other side with a beach view. The court said, what is being mitigated in a sense? Nothing. And so the court said, no, you can't do that. There has to be an essential nexus between what Nolans are doing rebuilding their house on that lot and the damage that's being caused by that redevelopment that you're trying to mitigate. And there was no relationship. Dolan was a case, and actually I was on that case. Dolan was in Tigard, Oregon, where the city of Tigard wanted to exact a floodplain, a piece of a floodplain, next to a plumbing goods store to build a bicycle pathway to connect a residential area to the main street that was where the plumbing store was located. The court said, well, what's the relationship between expanding a plumbing goods store and the impact on anything? And that led to what's called the rough proportionality test I'll get into a little later on. Both of those cases were administrative cases. Dolan was a variance case, and the California Coastal Commission, I forget what exactly it was, but it was not a legislative action. They were administrative actions. I just talked about Nolan. I'm going ahead of myself here. You can see a picture of the Nolan house after it was been enlarged, and you can sort of see where the people could go. People on the north or south couldn't walk along the beach at high tide because of the Nolan property, unless there was an easement across there. Now, very famous case. However, the California Coastal Commission years later hired surveyors to find out where the California state land actually was, and it turned out it was on the precise location where the Coastal Commission wanted the easement anyway. So they still got what they wanted, but we got case law out of it nonetheless. Dolan, here's the Dolan picture. Here's the floodplain in front of the plumbing goods store. I'm actually cited in the court case itself. And there's the plaque. So the city of Tigard, Oregon lost the case. I was the planner for the city of Tigard, but only after the city got into the Supreme Court. The lawyer called me up one day, 30 years ago now. He says, "Chris, I need to have somebody help us in the Supreme Court." I said, "You want me to help you in the Supreme Court?" They needed planning arguments for defending what they did. I said, "Well, Tim, the attorney, don't you have impact fees for roads?" He said, "Yeah." "Don't you want to, or transportation, don't you want to build a bicycle pathway connecting residential area on to the right here down to the main street to the left?" He says, "Yeah." And so you're going to build a bicycle pathway on the floodplain. Why don't you just reduce the impact fee by the $15,000 value of the easement? Because we do that all the time as an in-kind arrangement for transportation improvements. He said, "Oh, we never thought about that. We should have hired you before we got to the Supreme Court." Well, so I tried to help the city, and the city lost in the Supreme Court. I did my valiant best, and that led to the so-called rough proportionality test. And by the way, when the court ruled and the city lost, as part of the settlement after the court case, the city had to pay up $1.4 million in 1995. That was real money then. It's not so much money now, apparently, which works out to about $1,000 per linear inch of the floodplain that they wanted to get. So much of the focus now is going to be on the Dolan case, because the Dolan case says, I'll read it, it leads to the rough proportionality standard. There's no precise mathematical calculation needed, but the city must make some sort of individualized determination that the required dedication is related both to the nature and extent of the proposed development's impact. That's actually part and parcel of how we calculate impact fees. And we actually use a mathematical formula for impact fees, and we basically use these standards, although we don't follow the Supreme Court so much because a lot of states tell us that's what we have to do, including Utah and Georgia and 20 other states. Then along the line, we had another case called Kuntz versus St. John's, Florida Water Conservation District. Basically, in that case, the court said, well, in Nolan and Dolan, these were exactions. The Coastal Commission or the city of Tigard, they wanted to extract land or an easement from the builders, and that became unconstitutional. Kuntz turns out to be a monetary exaction. And the court said, oh, no, you can't just take money. You've got to show what the impact is, what the mitigation is, and that the money has to be related to the impact. And so here we have the Dolan rough proportionality test that doesn't need a mathematical calculation. But then Kuntz says, well, wait a minute. If you're extracting money as a condition of approval, you've got to calculate what the amount of money should be. That's a mathematical formula. So that raises the question that was actually raised in the Sheets case I'll get into next. But is Dolan moving from rough proportionality, this general wishy-washy stuff, because of Kuntz? Is it moving into a specifically attributable test? In other words, if this development causes X impact, shouldn't the exaction or shouldn't the mitigation be focusing on that X impact and no more, or no less even? And this language appears in the Sheets briefs. So here's Sheets. So George Sheets wanted to build it's actually a manufactured home, 2016, on a multiple acre piece of land. I forget how many acres, 8 or 10 or something. He's got to pay up a transportation impact fee of $23,000. He doesn't want to pay it. He pays the impact fee in protest, and he proceeds to litigate. The county goes to various state courts that always say, no, the county is using a legislative action through the impact fee ordinance. You can't challenge a legislative action, citing Nolan and Dolan and Kuntz, because those were administrative actions. So this bubbles up to the Supreme Court, and so here's the house. Wait a second.
The next one.
It's the next one. Thank you. Thanks so much. So here's the Sheets house, and you can see the dot where the Sheets home is located. It's in the middle of nowhere. It takes a lot of roads to get there, and he's in zone 6 of 8 zones for the county transportation impact fee. And you can see the fee schedule. So the county has calculated a fee under state law in California, under the state law that I helped write, by the way, AB 1600. So the county is doing everything right. Assessment zones, calculating the fee, getting rule numbers for mitigating the costs. And George Sheets says, no way, I'm not going to pay that. So he pays it under protest. And you can see from the fee schedule what he's paying. This is the actual fee schedule from 2016. So basically, Sheets says, wait a minute. Things like impact fees, even if they're legislatively adopted, they still must pass muster under Nolan, Dolan, and Kuntz. They're not immune from those decisions. And sure enough, the court said that's right. Actually, the county attorney for El Dorado County, in the hearing before the Supreme Court justices earlier this year, agreed that legislative actions fall under Nolan, Dolan, Kuntz. So that led to a unanimous decision by the Supreme Court, which is difficult to do these days. And the court then remanded the case back to California courts to figure out if the El Dorado impact fee passes muster under Nolan, Dolan, Kuntz. And it's in that setting where the Kuntz attorneys, the Pacific Legal Foundation, those are the attorneys, they're going to argue that because of Kuntz, the standard for review is not rough proportionality where no mathematical precision is needed, but in the case of monetary exactions, you need to have a precise mathematical calculation, and that will lead them to a specifically attributable test in the case of monetary mitigations. So that's going to be interesting for people like me in my field, impact fees and so forth, the extent to which the California courts say yes or no, and we may end up back in the Supreme Court on this very question of changing the Nolan standard from rough proportionality, which is loosey-goosey, to specifically attributable. So is the sky falling? These are my concerns. Are we headed towards a specifically attributable standard which is much higher, much more rigorous to do in any kind of exaction mitigation format, impact fees, including building permit fees? You could just imagine a large number of kinds of fees that we charge routinely might have to be recalculated under mathematical formulas. Would this lead to case-by-case impact analysis of each individual home? Right now we use impact fee schedules that apply broadly for the whole county or the whole city, and here's my house and here's the fee schedule, and that's that. George Sheets says, no, I want my own impact fee individually calculated. Is that where we're going to be headed with after the California courts have done their stuff? Would this require a service area for every parcel, which is part of the independent calculation? Could local governments recover the additional cost that this imposes on them. Yes, in every state I'm aware of that has impact fee statutes, and other states that don't have impact fee statutes but through police power and home rule powers, impact fee costs, the consulting costs, everything else can be loaded onto the impact fee itself. And so impact fees reimburse the county or a city for the cost of doing the impact fee. Or does the county give up and say, okay, we're not going to do impact fees, period. And oh, by the way, because we don't have impact fees, maybe we have to stop development all, across the whole jurisdiction because we haven't got the money to build the infrastructure to serve new development. Or do counties and cities just give up and eventually do NIMBYs win because of this argument? Well, if we can't have impact fees because they're too cumbersome, too costly to do, and we don't have the infrastructure, then therefore we shouldn't have any new development. That's how NIMBYs would win. So here are my questions to the panel. How much has the burden of proof shifted in the impact fee world? It used to be that the burden of proof was on the developer to show that his or her project was different enough to where the impact fee had to be modified to serve that individual project. Now, is that burden of proof shifted back to local government instead? How does Sheets change impact fee practice in Utah? I don't know, as much work as I've done in Utah. Do we need to do our own impact fee studies? Every impact fee ordinance allows the developer to challenge the impact through what's called an independent fee calculation study. If they do one of those, does that mean local government has to do its own independent impact fee calculation and compare notes? Right now, they don't have to. Do impact fees need to be based on more service areas? In Utah, most city and most county impact fees I've seen are county-wide or city-wide. And the farther away you are, if you're building a house and you're using the impact fees to build roads way over there, what's the connection? What's the benefit back to that house? Sometimes it's difficult to show. That calls for more service areas. So are we headed toward more service areas in Utah as a consequence? And also in Utah, most impact fees I've seen are based on just the house, the unit. A single family unit, apartment unit, they pay the same fee, or maybe there's a little bit of difference between the two. Are we moving towards the court basically saying you need to calculate impact fees based on the size of the house? Because we know from studies that the larger the house, the more the people live in it, and the more the people live in it, the more the impact, up to 3,000, 4,000, 5,000 square feet, some threshold. Are we headed that direction? So these are the questions and other questions for the panel. Thank you very much.
Well, either those questions or any questions that you have for the panel here, just open it up and now is your time to ask some questions of the panelists.
Actually, I'd like to get the panelists' response to, do you know much about the Sheets case, or what are your offhand thoughts about it? And maybe I'm wrong, so.
No, but you're much more researched than me, so. So at least for me on the Sheets case, I saw it a little bit different than you. Not so much the sky is falling as it opens up a lot of new opportunities for us. I think because as it gets tested and it gets challenged, I hope it's going to bring more clarity. It's going to bring that there's a lot of things right now. A lot of times we will go to a city and at least I don't know, depending on the city, I don't know if the impact fee is to buy into existing infrastructure or to buy into infrastructure needed for future growth. And those are very different things when they calculate the impact fee. And different cities figure it differently. So I don't know if the Sheets case is going to test some of this stuff. And as we look, I believe there's some impact fees in Utah that have used almost the exact same logic to argue where they want the fee to be, as was used in California. So, and you're going to have to tell me, at this point, it hasn't been settled in California, right? So it's back to the California courts, and until they rule, we still really don't know what that precedence is there.
Well, they have to rule first, and no matter who, one party will lose, and so they'll appeal back to the Supreme Court. So it'll be 2, 3, 4 years before we get the final say on that, is my guess.
On the California case. But for the Supreme Court, we at least have that gives us new guidelines.
That's right. At least for now, under the Supreme Court ruling, impact fees and other kinds of similar mitigation strategies are subject to Nolan, Dolan, Kunst, which elevates the analysis you have to do to show that the mitigation itself is related pretty tightly to the impact that's being mitigated. That didn't used to be the case in impact fees. I mean, you still had mathematical calculations, but you were immune from the constitutional tests because they were legislative in character and not administrative. So that is a really big change procedurally. Also, Sheets built his house at the wrong time. Had he built his house today in the same location, in the same county, the impact fee would have been $6,000, not $24,000. Because impact fees change all the time based on the projects you're doing.
So I would add to that, if it's okay.
No.
Here, I would say, so as I've looked at this case, and of course, as you've heard it discussed today, it did decide that very precise issue of legislative versus administrative activities. And if you look at this case in conjunction with the impact fee law that we have in place right now, not having any additional guidance from the courts, we're probably in Utah still in a place where if the impact fees have been, the analysis has been done, in my opinion, under the statute as it says today in Utah, then the impact fees are justifiable in the state. Now, justifiable case by case, I'm not going to speak to, but our codes are pretty robust when it comes to those types of analyses and making sure that we're doing those as a group holistically. This case is really interesting, and if you go and read it and look at the concurrent commentary, it's really great. And this case is really great because after all these years, and I'm sure Chris feels this way, after all these years, it's almost shocking that this particular question of legislative versus administrative has not come and bubbled up to the court. And then, of course, to have the Supreme Court be unanimous is quite remarkable. And so I think we can take guidance from that, and we as local government should take guidance from that. But until we have some additional court rulings, I think we will be in flux. Now, the other thing that I thought about as I was driving here thinking about this discussion today, that it's really also very difficult to have these conversations in a vacuum on either side of this ledger, right? Because I drove here on lovely roads that got there a lot of different ways, through a lot of different funding mechanisms, and all of which come right back to us, right? We also have the scenario you heard talked about earlier today, and that is real, which is you have to pay for those things somehow. Somehow those benefits to us as a community, somehow the ability to flush our toilets and turn on the water and brush our teeth in the morning and drive to the places we need to drive, do have to be funded. How that occurs fairly, how that occurs under the Constitution. Again, I would encourage you to go look at this case because there are some lovely quotes about that, and one that I took particular note about that I wanted to read to you, and then I'll pass the microphone here. But this is from Gorsuch is concurring. That's a mouthful, and he says the comment that I liked is. So today, the county essentially confesses error and the court corrects the state court's mistakes. It does so because our Constitution deals in substance and not form. However, the government chooses to act whether by way of regulation or statute or ordinance or miscellaneous decree, it must follow the same constitutional rules. And so if you look at, there are a few little nuggets like that throughout this court case. Like I said, I'd say go read it, because it is, while it is a really interesting and dramatic turn of events in some ways, it's not at all in other ways. And as it relates to how we do things in Utah, I would say, again, it's not at all, except for interesting that this legislative versus administrative dynamic hasn't been brought up until now.
I have two thoughts. One, I'm glad you brought up the concurring opinions. Not that I read a lot of Supreme Court cases, but 5 justices wrote separate concurring opinions. That's unheard of. I mean, you agree or you don't. I've seen 2 or 3 at a time pose different opinions, explaining why they voted against the majority. But here you had 5 justices agreeing among themselves why they voted the way they voted, but they had different reasons for voting the way they voted. And that's, again, fascinating. You read it in its own right. But in terms of Utah and every other state where impact fees are used, the court is saying, from my perspective, follow Dolan. And what does Dolan say? That mitigations are individualized determinations of the nature and extent of the impact on whatever it is you're trying to mitigate, facilities in this case. We've been designing impact fees in Utah forever, not based on individualized determinations, but based on a whole analysis of a whole class of land uses. As I said earlier, in many parts of this state, I've seen impact fees on residential that were the same for every kind of residential use there is, from a studio apartment to a mansion. My thinking is that I think the court meant what it said. Legislative actions fall under Dolan. Dolan requires individualized determinations based on the nature and extent of that project's impact on facilities. I think that's the key change that we're going to be seeing in future litigation.
Yeah, and I do think that's key too. And I think that has to be coming out in future case law, because again, if you read the other concurrence, which is the 3 justices, they specifically and explicitly address that very particular issue. And they say, listen, we did sort of say that, but that's not really what this court got to. We'll have to see what that means in the future. And that just little section of their concurrence is also fascinating. I won't read it to you, even though I want to, because it's really good. It's really interesting. But go take a look at that, because it does address that very particular. It calls it right out, just as Chris has, and it addresses it very particularly by saying, we'll just have to wait and see. So it's interesting to take from that and then understand what to do. We'll understand what we should do, right?
So my 31st book, a publisher has come to me and my co-authors on impact fees to write a book about guiding future calculations for impact fees under Dolan. Until now, we've been immune from Dolan, but now we're not. And so we're going to write our book giving a guidance to impact fee practitioners, and our book will end up in court as expert testimony in some fashion. So under cross-examination in Utah, a future impact fee case could come and, have you read Mr. Nelson's book? No. Do you know what it says? No. And it could be entered into court, and the plaintiff could show the judge, well, wait a minute, Dolan now applies to impact fees, and the city or county impact fee expert hasn't read the book on how to do that, therefore we win. We'll see.
Maybe that's what happened.
One of the things that I noticed in the Sheets case, and you kind of alluded to that, is in each of the concurrences, all of them said, we're not deciding. We're not deciding. We're not deciding. Like repeatedly, we are only deciding this, whether Nolan and Dolan applies to legislative decisions. And I think in Utah, we have always been under that understanding of them applying to both administrative and legislative decisions. And the Utah case law has always supported that we follow a roughly proportional system. So I think that in relation to the effect on Utah, this case isn't as startling as maybe other states have viewed that, because we've already been following that case law.
So, and I would agree with that, but I hope it's startling enough. Our hope is that cities start to bring in the public, the builders, the developers earlier in the process. I don't know how many of you have been involved with it, but more times than not, we get to start to review an impact fee after it's all done. And then you have this narrow window to look at it. And I think this changes that standard of what the city has to do enough that they're going to go, no, let's get all the players to the table so it's not challenged. At least I hope. Because a lot of times we'll review on and go, no, there's no problem, or there's a little problem and it can be tweaked, but it would be so much better if we could go at the very beginning when they're starting through it and say, okay, let's look at how all of this works. So I don't disagree with your statement, but I'm hoping it's enough that it backs that planning process to a little bit earlier stage.
You know, I think the other thing I'll just add that's interesting about this, and I now have worked in a city that's almost fully built out, and impact fees looked one way, and I'm helping a city that is not, and the impact fees look a whole different way. And I think it'll be interesting as this all plays out to understand what the impact potentially of a different kind of calculation will be on truly the situation where there is a lot to do and it's really expensive. We may be in a situation where we like this game plan even less than we like the current game plan.
That's true.
And I'm sorry, I saw a question I interrupted.
I was just curious. You said you'd like to get the developers involved earlier. What do you think their contribution would be to impact fee studies?
Okay, so I have to repeat the question so people online, is it so if I do it wrong, tell me. You want to know why I would want to have the developers in earlier and what their impact would be?
Yeah, and what their contribution.
Or what their contribution would be. So I'm not sure I know how to answer that, other than that I know as we review them, there will be certain mistakes we will see. For example, we will see some cities that will value land for say, the parks, and they'll value it different than we might value it. And so if we could have that discussion before all of the numbers were built out, we could get to maybe a less contentious solution. And it's possible we're wrong, but it's possible the city's wrong as well, and say, okay, well, let's look at that at the front end before we build out the whole calculation.
In the back.
So along those same lines, as a profession, I'm a civil engineer. We consult for small municipalities to calculate their impact fees. And I volunteer as a citizen planner. That's why I'm here today. And so I get nervous about developers' involvement in impact fees, at least from the calculations that I'm doing, because they are based on some engineering analysis and a lot of tools. I mean, for example, we had a mayor that wanted to have public opinion on which water project needs to be done first, and we had to explain that we're the engineers, we're going to tell you which ones are for health and safety need to be done. This really isn't a matter of opinion, and so maybe with parks you could discuss some different approaches, but and I guess one of your other comments, I think it's a misunderstanding among developers in general that a city can come up with an impact fee and put in some data for existing deficiencies, but by state law, we cannot. We have to first analyze the community and say, what are the existing deficiencies? And those have to be paid for by the tax base. Impact fees can only be for future development. So I would be concerned personally about too much developer involvement when we come up with these numbers. I guess it's not a question, just a statement, but anything you want to respond to.
Are you going to summarize what she said first for everybody online?
So the microphone in this room is better. It's this computer, so you probably don't need to review.
Oh, good.
Okay, good.
Thank you.
Well, so, no, I would like
We
to
were
comment
just
on it.
following instructions.
Yeah, no, we were told. No, and I appreciate you making that comment because I don't want to be misunderstood on that. We don't want uneducated developers or the public saying, here's your next water project. I agree, the experts need to weigh in. But often we have the experts internally as well. And so sometimes to be able to have those conversations and say, okay, well, what are we going to do and what is the best way to do it? And sometimes just the evaluations or the calculations will be incorrect. And so we have to look at them. And we know that because when we review them after they're complete, we get changes often that, oh, wow, we missed that. And so we're not looking to direct what you do when you're developing it, but we're looking to be more involved and say, let's get a better, more comprehensive and more collaborative impact fee. Again, the costs are enormous. If we don't get that infrastructure put in as needed, we can't continue to build. So it's super important to us, but we need it to be fair and accurate.
So I do third-party reviews of impact fees before they're adopted, usually for developers, but not always. And things I look for are mathematical errors, which are frequent for certain consultants. Haven't run so much into that in Utah, thankfully. Especially in the area of what we call revenue credits. So if you have a dedicated tax base for roads, let's say, and then you have road impact fees on top of the dedicated tax base, the law in Utah and elsewhere says you have to give a credit back for the present value of the future stream of dedicated road tax revenue that's going to be used for roads, and you need to adjust that against the impact fee. Otherwise, development pays twice for the same road. They can't do that. Many local governments don't know how to figure that out. It's not difficult to do, and I teach them how to do it. But that's one thing I look at particularly. Something else, level of service. Maybe the city has 5 acres of park per 1,000 population now, and they're happy, but maybe it's just not quite as much as they wanted to. So they take it to 6, and then you have that deficiency you mentioned earlier. Many local governments recognize the deficiency, but have no method to remedy the deficiency. So I look to the local government to say, okay, you've recognized your deficiency, or maybe you haven't, but here's what it is. How are you going to make it up? Oh, well, give us some ideas. Well, maybe lower the impact fee down to what you have, or do this and do that. So I look at kind of a menu of things as a checklist to make sure that the impact fee when it's being built is done, fairly by the law, by the Supreme Court requirements. Having said that, we're in a court case in Georgia now it's a $20 million impact fee court case, and we had one in Utah here 4 or 5 years ago. There was a $33 million settlement. Another one is going on in Washington County that could be a $300 million bill for somebody because of not doing these, in my opinion, not doing these due diligence things.
Does that make sense? Does that get at your question? Because he said it way better than me.
No, those are wonderful comments. I like
That's why we brought him.
How does this relate to state regulations, particularly water, storage, source, all that kind of stuff? Because in our city, we're redoing impact fees right now, and it's very problematic because they're saying our system's deficient, and it hasn't failed us in 20 years.
The sky is falling because even though this is an impact fee case, and you can fix impact fees to meet Nolan and Dolan, but there are many other fees government charges that are kind of back of the envelope fees. You have some numbers, you put things together, but they don't really pass muster under Dolan, in my view. So we're going to see engineering fees or architectural review fees or all kinds of other fees that you're going to say, okay, where is the individualized determination of the nature and extent of the impact of that project causing the mitigation? It's not the impact fee outcome that I'm worried about, so it's everything else I'm worried about.
So can the panel ask questions?
Yeah.
Okay. So based on what you said, as I read it, the Sheets case is very specific to impact fees, but I hear you saying this could spread out to other fees, which has been a question I've had for a long time, because you're right, it seems to be a concept that applies, but
will.
they were pretty specific.
Well, a very wise law professor would always say something like, it's not what the Supreme Court says, it's what all the other judges say it says. And that's where you're going to get, it's an easy lift to say the court decided this impact fee case, but the factual situation is so similar, it's going to apply to architecture review fees or water tap-on fees or anything that's not an impact fee in Utah, which is where most of the money comes from, by the way. Impact fees only pay for a small share of things in Utah.
And to your question, I think that it's going to be difficult to ascertain the effects of these other requirements that we all have and the pressures that they put on the things that we do. I think water is a great example, especially now as we go forward. But there are others, right? I mean, I think in the same vein, you have the stormwater requirements that are extensive and cost a lot to comply with. I think that those are real, and I think some of our sister states have seen they're the front runners in some of those types of things. California is a great example to look at with regards to pressures of not just a normal engineering type build of a certain piece of infrastructure, but all of the other Christmas tree ornaments that get put on that infrastructure because of the other things that a local jurisdiction, a state jurisdiction, a federal oversight jurisdiction might have interest in. I think it matters. And how we blend that into an impact fee and make that appropriate is a great question. I'm not sure I have the answer to that.
There was a question back here. Yep.
So what do you mean, give me some thoughts on your individualized requirements. Does that mean square footage based, or can you put them in groups of maybe houses 1,000 to 1,500 square feet, or you have to determine how many people are going to live in that house and allocate it based upon that? Individual, what does individual to you mean?
That's a great question. So what is an individualized determination? At one extreme, it would be each individual house. Now, does that mean you count the number of people living in that house when it opens the doors? We use an average over time. Houses have more people living in them or few people living in them, but we can say, okay, an average 1,200 square foot house will average about 2.2 people per unit, forever. Where a 4,000 square foot house would average about 4 people per unit forever. So my thinking is that you can take census-based averages. Now, the census doesn't give us square footages for houses. They give us number of people living in a single-family house or a duplex or a townhouse or apartment or a condominium. So we can get the number of people per unit by type of unit, but it doesn't give us size of the unit. Do we have to find a way to go to size? Well, thankfully in Utah, your assessment system is so good. You can take all of the single-family homes and their square feet on the one hand, and then you take the census people per housing unit on the other hand, and you can do some other data things through the American Housing Survey, and you can create a simple formula that says, okay, every square foot is calculated as such, and so your impact fee would be on a square foot basis. But I think that an acceptable way would be to have a number of categories, the 500 to 1,000, 1,000 to 1,500. So you can probably have these scaled fee or these bracketed fees. But be wary because I've seen this happen where if you have you're building a house that's 1,501 square feet, are you going to be paying an impact fee based on the 1,500 square foot bracket or the 2,000 square foot bracket? And that one extra square foot might cost you $1,000 when the construction cost is only $100 per square foot or $200 per square foot. So, but there are some ways to modify that too. Anyway, I spoke too long on that, but I think that we're headed towards square foot type impact fees for residential, and maybe fall back on brackets reflecting the square foot size.
So the outcome that I see from this is that you wouldn't necessarily have a fee schedule that or an assessment of that, but you'd have an approved equation. Is that what and that you would then just plug in the variables, and therefore you don't have the predictability that a developer can say, okay, I know what this is going to cost me. They have to then plug in those values for every single.
I think
I don't know. Is that the outcome that I'm seeing? Because that's what I'm processing.
that's the worry I have. That does the individualized determination, is it based on each individual house? And that's why I say service area. Does each house have its own little network of impacts on roads? And then you have to pull in transportation engineers and their models on each individual lot, and that's a mess. I don't think it's not reasonable either. I think reason will eventually prevail on this. But I do think that we're headed towards size-based impact fees on residential. We already do it now for non-residential.
We plug in square footages for commercial and institutional. And
yeah, and I think we should move towards the same thing for residential.
Which I think,
but I also think, I'm sorry.
Well, no, I was going to say, I think that gives us a flaw too, though, because we have some of our biggest houses are lived in a few weekends out of the year. When you go into our vacation areas, that's where we have 30,000 square foot homes, and they sit empty most of the year. Nobody's short-term renting their 30,000 square foot home. No, but you're right. I'm just saying it's not as it. The more you talk, the harder. Okay, the sky is falling. You win.
Right,
Is that
and
what you
the
wanted?
the flip side, that I was just thinking is there are communities in this state. I know them very intimately. That you could have 1,000 square foot home, and I promise you, you're having 10 to 15 people in some cases live there on a consistent basis, not just a one-off basis. And so a number of people, square footage, it breaks down a little bit from a reality perspective to your exact point, right? That's right, exactly. So it's really interesting. It's interesting. And it's an age-old problem, truthfully, because we have these problems today as it relates to making the calculations.
Well, and I say, it's not who occupies the home today. You're looking at overall averages for the class of homes up 1,200 square feet, let's say. Otherwise, you're just doing a turnstile impact fee. People going in and people coming out, and
counting heads. It's not a good idea. That's right.
I was a planning director once, and I was told by my planning commission chairman one day to send my staff out and we had a blood test. Only related people could live in the same house, right, under the zoning. So shall I have my zoning administrator head out with blood litmus test kits to sample the blood of all of the people living in the house to make sure they're blood related? No. But that's what the law says. No, I'm not going there.
Got a question over here, and then we'll go back here.
It was more just a thought of the kind of square footage based calculations. If that were to happen, I work for a city that builds very large homes. And a lot of times there'll be a home that exists, and then there'll be a large addition onto it. We often don't charge impact fees because there's no new real impact. Sometimes there is for sewer, but oftentimes it's a single family home. They've just doubled the size of it. And yet that might bump them up 3 brackets. So it's always calculated, we take a snapshot in time, we don't know the impact. So it's more of just a thought I was having of how would we handle that type of, someone applies for a building permit for a 1,500 square foot home, builds it, and then a year later comes for another building permit to expand that to a 15,000 square foot home.
So, two ways I would address that. One is that at a certain point, your incremental people per foot just flattens out. And that's depending on where you are. Maybe in this state, it's 4,000 square feet, whatever it is. But then if you have a very large house, oftentimes you have gardeners and housekeepers and other people coming to the house and maintaining the house all the time, and they're putting wear and tear on the roads. And if they're housekeepers, they're putting wear and tear on the water and sewer systems. And they're additive to the primary residence. And we haven't studied that incremental effect yet. Maybe that day is coming. But for now, you would just use census data and some other data to show that, okay, things flattened out at whatever the square footage is for your community. Maybe it's 15,000 square feet in some places, and maybe it's 2,000 square feet in other places.
Back here.
So this is something I've thought about a lot, especially in our communities. In western Weaver County, when we were redoing the general plan, it was very difficult to convince these 1 acre lot folks to go to smaller properties or allow these smaller land parcels. And one of the selling points that I kept telling them is if you build 1 acre lots across all of western Weaver County, your taxes will be so high you will move. And so I think the impact of how many people in the home is not quite as impactful as the street frontage. So as a way of looking how to help with affordable housing and helping make the impact fees work towards affordable housing, I would suggest making it more linear feet of street, because that affects all of your infrastructure running down that street, the linear feet that need to go to each home. Distance from the center of the community is another factor that really impacts community much heavier than any, I would say the square footage of the home is minor compared to the linear feet of frontage.
I like that argument. Thank you. Yeah.
We are out of time, I'm told, and so we'd like to thank our panelists for being here, and